Hi everyone, my name is Wanjiku Waithera. I'm an advocate of the High Court of Kenya. On today's session, we will be talking about bail and bond. The Constitution under Article 49 guarantees every arrested person the right to bail or bond, whether upon charge or upon arrest at the police station. And the purpose of bail and bond is to secure attendance of an accused person to ensure that they attend court religiously up until the time when their case will be determined and they are either acquitted or they are convicted for the crimes within which they've been charged with. And the main distinction, I would say, between bail and bond, bail is normally an amount that is set by court, which a person deposits within the court to ensure that they attend to guarantee that they will attend court religiously. On the other hand, a bond is a legal undertaking with or without security, again, that guarantees that this person will be able to attend court. And where they fail to attend court, then the security deposit which they have deposited may be forfeited to the court. There are various types of bond that are guaranteed. I mentioned a police cash bail. This is a kind of a bail that is paid at the police station before a suspect is arraigned in court. Police bail is paid at the police station, and once a suspect, because at this point they are yet to be charged in court, so they are still a suspect. Once a suspect has paid that police cash bill, they'll be issued with summons for them to appear before court for plea taking. And upon appearing in court for plea taking, then the police cash bill is refunded to the person who deposited, and a second cash bill directions will then be issued by the trial court. There's another form of bail that is normally issued before charge, and this is anticipatory bail. It's one of the least common types of bail that is issued, and it's issued in special circumstances where there's a likelihood that there's a likelihood that there's going to be misuse of legal processes to have a person arrested. It's issued by the High Court, and it's guaranteed under Article 23 of the Constitution. So once a person has been arraigned in court, they've taken plea, and they've denied the charge, then this is where the trial court now sets the bail and bond terms. And you might ask yourself, are there offenses which are non-bailable? Under the current constitutional dispensation, all offenses are bailable. There's no offense which can be said that this offense, one cannot be granted bail or bond for. And the reason for this is because, as a general rule, bail can only be denied where there are extreme compelling reasons to that the court has evaluated and they've determined that a person is not fit to receive bail or bond. When you look at the Terrorism Act, it does speak to Article 49, where it states that the rights of a person who's been charged with an offense under the Terrorism Act may be limited to the extent that it ensures that the rights of the suspect together with the witnesses are protected, and to also ensure that there is no interference with the ongoing investigations. So for every offense, then the right to bail or bond is guaranteed. The other thing that we will be talking about is what it means, what compelling reason means. So when a court is evaluating whether or not to issue bail or bond, or the kinds of sums to set for bail or bond, there are certain factors that the court will evaluate. And these include, one, the nature of the offense and the incentive to abscond. Like I mentioned, every offense is bailable. However, you will find that where someone is charged with a capital offense or offenses of certain nature, there's the risk of this person absconding. And so the court has to set the bail and bond terms to the extent that will ensure that this person does appear before court and continues to answer to that charge. Other things that the court considers include the character of an accused person. Has this accused person been charged previously and they absconded in court? The court will also look at what is the likelihood of interference with witnesses. And I'll give an example. For instance, you have an accused person, say, who has been charged with defilement, and the victim who they are alleged to have defiled is, say, a child of a relative, and they live within the same community. The court may look at the circumstances of such an offense and say that there's a likelihood that if this accused person is released to go back to the community, then there's a real risk that they may interfere with the victim, they may intimidate the victim, and this may lead to the collapse of the case that has been leveled by the prosecution. And so these are some of the things that the court will look at to ensure that they balance between the rights of an accused person as well as the rights of the victims. You also have circumstances where an accused person is said to be a flight risk. For instance, you have an accused person who, say, is a foreigner or has a lot of travel history. The court may determine that such a person is a flight risk and may require, even at the point where they are issuing bail, they may set what we call conditional bail and bond terms, where that such an accused person is asked to, say, deposit their passport and travel documents in court, or they're asked to maybe report to the OCS of the locality within which they come from. And so all these factors, another example maybe I could give is where you have an accused person who, at the time of arrest, they were victims of mob justice. And so the court will look at the security of such an accused person. What will happen if that accused person is granted bail and bond and they go back to the same community that had initially, meted violence against him? Does it mean that they'll go and their life is at risk? What is the risk of, security and public order being maintained? So these circumstances, the court will normally look at them holistically, and the court will determine not just the amount of bail and bond, but also conditions that can accompany the bail and bond terms. Now, what happens when an accused person goes to court and they are denied bail, or they are granted bail and bond terms which are very extringent and they cannot meet them? There are certain remedies that are available to such an accused person. The first one is you can approach the same court that granted the bail and bond terms, or the trial court that will now be conducting trial of your charge, and asking for what we call a review. A review is basically an invitation to the court for them to be able to lower or alter the conditions that were set by the plea-taking court. And second option that is available to an accused person is for them to seek revision to the High Court. We've seen this mostly with the recent cases where protesters were being charged, in the recent protests that the country has faced. Trial courts would set what we call, very unreasonable bail terms, and you'll see the accused persons now moving to the High Court, which has supervisory jurisdiction, and asking the court to at least review their case and have such bond terms lowered. And something else that I ought to have mentioned is that where the court cannot immediately make a decision on the kind of bail and bond terms that they ought to impose, possibly because all the factors have not been laid to such a court, the court may call for what we call a pre-bail report. A pre-bill report is usually prepared by probation officers. They will visit the accused person in custody. They will visit their families. They will talk to the investigating officer. They will talk to the leadership of the locality which they come from, just so that they can understand the kind of lifestyle and or the accused person leads, together with collecting the views of the victims and the complainant. And once the pre-bill report is tabled before court, although the court does not necessarily need to take it doesn't necessarily need to go with what has been proposed on whether to give or to deny bond. The circumstances which have been highlighted may influence whether this court will issue bail or bond terms. The other thing that I need to mention is what is the place of a complainant or a victim when it comes to, challenging whether an accused person should be granted bail or bond terms. Remember, under the new current dispensation, the rights, a victim of a crime or a complainant has the right to inform the court and to give their views to the court, and which the trial court will take into consideration while determining whether to grant bail or bond. And this is a protection that is also given by the Victims Protection Act. And so as a complainant or as a victim of a crime, you can give your views to the trial court either by, issuing a sworn affidavits to the court, where you indicate whether you're opposing to the issuance of bail or bond to an accused person. You can also give your views through the office of the Director of Public Prosecution. And where bail or bond is denied, a court has to inform the accused person why they have denied bail or bond. It should not be enough to tell you that we shall not be granting, the accused person is detained up until when the trial shall be completed. The court has to set the reason why it has arrived at such a decision. In certain instances, you will see a court denying bail or bond at the onset and giving conditions like, bail shall be set upon hearing of certain witnesses. And this generally ensures that the witnesses are protected and there's no risk of witness interference throughout up until the point when they have testified. And once that such a risk has been eliminated, then the trial court can proceed, go ahead and issue bail and bond terms. That is all for today's session. Thank you.